Hello, welcome everybody to today's webinar, which is on the Register of Overseas Entities. We are recording the event today, so if you want to share it with anybody, then you can do that. And also the slides will be available as well, so you can take notes if you want to, but I will be sharing the slides at a later stage. I've also been joined by my colleague today, who is Rob Scarf. Just to tell you a little bit about us, my name is Liz Kinsey, and for those of you who haven't been on one of our webinars before, I'm the Managing Director for CRO, and Rob is one of the managers in our Cardiff office, and you may have had dealings with him if you use our CRO info service. But Rob heads up the service that we provide for the Register of Overseas Entities. So from an operational point of view, he's very much in the forefront of the dealings with Companies House and the registration, so he'll be able to answer some of your questions later on as well. A little bit of background about myself. My background's in company secretarial work, so I'm always looking at new legislation, which is why I've been involved in the Register of Overseas Entities as well, and just trying to get to grips with what's needed. So we'll be giving an overview today of what's required. So if you need to advise clients, if they come to you and they need to be put on the register, then hopefully you'll have more information. Or if you're considering being an agent yourself, then hopefully you'll know a little bit more about what's going to be involved. There will be an opportunity to ask questions as well. So in the corner, there should be a question box. So if you just want to submit any of your questions, and we'll go through as many of those as we can at the end of today's session. So I'm just going to share my screen with you. And I must apologise as well because the slideshow for the slides isn't working. We had some technical difficulties. I've been in touch with GoTo as well, and they've done an update, so it may have something to do with that. So I won't be able to show the slideshow. I can show the slides in the editing format, but apologies that it just doesn't look as slick as it normally does. So just share my screen. Right, so hopefully you can see that now. So just to have a look at what we're going to talk about today. So I'm going to give you an overview of how the Register of Overseas Entities has come about. We'll look at the process of registration as well. We'll look at the annual statements that are required and actually the removal process, which is now available for companies that no longer own any property or land. And we'll look at some examples of verification as well. What we've established over the last couple of years is every registration is unique and all have their own complications. This isn't a straightforward process at all, and it's very much down to the agent to ensure that they've got all the documentation that they require for the registration to be completed and that that information has been verified as well. So how has this register come about? So the Register of Overseas Entities came into force in August 2022, and this was through the Economic Crime, Transparency and Enforcement Act. So why did they decide to do this? Well, this was very much on the back of the war between Russia and the Ukraine, and it was established that a lot of UK property or land was owned by overseas entities, but it wasn't possible to tell who owned those overseas entities. So when they were looking at putting sanctions in place, it wasn't possible to see if they were owned by Russians that they would need to impose sanctions for. So it was decided more transparency was needed in this area. Now, it's very much the Land Registry that holds this information, and they knew that out of all the owners of land and property in the UK, over 30,000 were overseas entities. Now, they shared that information with Companies House, who were best placed to be able to provide the register, as they already provided similar registers for UK companies as well. So Companies House is just where the register is held, but all the information comes from the Land Registry. But any notifications that are sent out are usually sent out by Companies House as well. So the register was to establish who owned these overseas entities, and to declare that on the register at Companies House. Now, the purpose of the legislation also wanted to look at what was meant by an overseas entity, and that needed to be defined as well. So it's any corporate body or a partnership or any other entity that is a legal person in its own right under the law under which it's governed. So that's very much stated in the legislation. Now, for those that didn't comply in registering, there were severe sanctions. That included restrictions on buying and selling property. So when an overseas entity registered, they would be issued with a unique identity number, and that number would be needed if they were buying land or selling land. They need to give that number to the Land Registry to complete the transaction. So if they didn't have that number, then they wouldn't be able to buy or sell any land. Also, if they didn't register for any of the offices of the company, there were quite high fines. They were talking of thousands of pounds if they didn't complete the registration, and potentially imprisonment as well, or both, if it was a severe situation. So who needed to register? Well, the register was retrospective, but different dates applied in different parts of the UK. So if an overseas entity had purchased land or property on or after the 1st of January 1999, and the property was in England or Wales, then they would need to register. But for Scotland, it was December 2014, and in Northern Ireland it was August 22. So it depended where the property was as per the dates on whether a registration was required. On top of that, any entity that had disposed of land quite recently, so between the 28th of February of 2022 and the 31st of January 2023, they would also need to give details of any land or property that they disposed of during that time period as well. Now, this register is ongoing, so if any new overseas entity wants to purchase land, then they would need to register before they can complete that transaction as well. Why are people using overseas entities to purchase land and property? One aspect of that would be so that their identities can be hidden, and also there were certain tax benefits as well. And the skeptics amongst us would say that this register was also about identifying those people, so that if they owed any tax, then they could track them down and have those conversations with them. So as part of the registration, a UK regulated agent would also need to verify all the information before the registration could take place. Now, this is the first time that we've seen this type of verification on a UK registry. Some of you may be aware that there are other changes coming into force under the ECCT Act next year for UK companies, and we're going to have to verify directors and PSCs. But this was the first time that we've seen where they put an agent in place. They'd have to be registered with Companies House. They'd have to be registered under the anti-money laundering regulations as well. And this was the first time that we'd seen this for UK companies. Now, these agents are different from ACSPs, which is the next step of things that we're going to see for UK companies. So they're the authorised corporate service providers. So it's two different registrations. It's not the same thing, just in case you're aware of the changes that are coming in next year for UK companies as well. So for the overseas entity, it's important to establish who the beneficial owners are. So what do we mean by a beneficial owner? On the register, we have to submit who are registrable beneficial owners, but not every beneficial owner will be registrable. And on the next slide, we'll look at who would be a registrable beneficial owner. But when they're talking about beneficial owners, they're looking at people that could be an individual person, it could be another legal entity, it could be a government or public authority, so some property, it could be an embassy, so it could be owned by a foreign government, or trustees of trusts as well, or a member of a firm that's not a legal person under its governing law. So that's the definition of beneficial owner. When we look at who is registrable, then there are certain conditions which are known as natures of control. Those would be that the beneficial owner holds directly or indirectly more than 25% of the shares in the company, or holds directly or indirectly more than 25% of the voting rights. They could also hold the right to appoint or remove the majority of the board of directors, or have significant influence or control over the entity. So they're similar to the PSC requirements, if you're familiar with those, for UK companies, but they are slightly different as well. Some of those are quite easy to be able to prove who is the registrable beneficial owner when we're looking at who owns the shares. It's not as easy to prove who has significant control. So it is up to the overseas entity to declare that information and to show proof as to why that person would have significant control. So you could have a company where you've got 5 shareholders and each shareholder owns 20% of the shares. So in that situation, they don't meet the criteria under the nature of control because nobody owns over 25% of the shares. Now, it could be that one of those shareholders does have significant control, and there may be a shareholders agreement which could confirm that and which could be used as proof that they have that significant control. But it's possible that nobody does, and they all actually just have 1/5 of the company each. Now, in those situations, there's no registrable beneficial owner. But as part of the register, you can't simply state there's no registrable beneficial owner. You have to declare somebody who acts on behalf of the company. So in those situations, you would then go and register the managing officers of the overseas entity. So you always have to declare somebody. You can't just say, like with a PSC, there's no people with significant control. You can state that, but you then need to go a step further so that you are declaring somebody that is responsible for that company. So once established who the beneficial owners are, that information then needs to be verified by a UK regulated agent. And the agent must confirm that all the verification checks on the beneficial owners or the managing officers have been completed, and the agent has to complete a statement to say that that has done. So that part, the verification part, is on the agent, and again there can be quite severe penalties if that's not carried out correctly. So what must the agent do? Now, there are differences between the anti-money laundering regulations and the Register of Overseas Entities verification procedures. One example of that is for the ROEs, it's not risk-based. So there's different things that we're looking at when we're completing this verification process. Any documents that are provided by the overseas entity must be from a reliable source and must be independent from the person whose identity is being verified. And when we talk about independent sources, it would be the Passport Office is an independent source, so that could be a proof of existence for that person, because that's not coming from them directly. The Passport Office is an independent source. But when you're looking at this information and who's allowed to verify that information, it can't be a family member or a close associate or somebody that they have a business relationship with. Again, the verification needs to take place and be independent from the overseas entity. And that can cause some problems as well, especially when they're looking at documents being certified as well. It needs to be an independent person that doesn't have a relationship with that person. For the verification process, when we first looked at this legislation, there was guidance from BEIS, and the guidance was vague and inconsistent, and like when we're dealing with the anti-money laundering regulations, a lot of it is down to the agent to actually apply that how they think that should be applied. So you may see that agents apply the legislation in slightly different ways because there isn't strict routines on what must be followed. And as I said at the beginning, every case is unique. And sometimes you end up going down a rabbit hole to try and actually find out who is responsible for this company and who is the ultimate beneficial owner. But it takes a lot of digging, it takes a lot of time to make sure that you've got the right documentation and that can be verified. We are a regulated agent, and our approach is that we check every single part. If there's a complicated company structure, we will check every single part to ensure that we've completed our verification correctly. Some other agents may just go to the end because that's how they've decided to carry out their verification, but because there could be severe penalties to the agent as well, we make sure that we check every step of that company structure, because you can often have a company being owned by a company being owned by a company, and then it splits off in different directions and then comes back together later on. Some of these company structures can be very complicated, and it's important to follow that process through to make sure that you are registering the right people in the end. It is the overseas entity's responsibility to provide this information. It's the agent's responsibility to verify that information. It could be that the overseas entity has to write out to people to confirm who are registrable beneficial owners, but they must show and prove that they've taken every step that they can to identify who the registrable beneficial owners are at the end of the day. As I said, every registration is unique. Some of them can be a lot more straightforward, and I'll look at a couple of examples in a moment. As for what information must be verified, it's the agent's responsibility to look at the evidence, match the identity, and confirm that the condition is met of being a registrable beneficial owner as well. And then that person's identity must be verified as well. And you need to look at identifying that they're a real person and also their address information as well. And it does state in the guidance that any address verification must be dated within the last 3 months, and it must be from an official source. So it could be a utility bill or something from the bank, but it must be dated within the last 3 months. And sometimes when you're going through the process of collating all this information, some of that can be out of date at the point that you're going to register, so that will need to be renewed as well, so that you make sure that at the point of registration all your documentation is valid in there as well. Documents can be issued by an official body. There are lots of other registers out there that are similar to the UK's, and that everything can be detailed on the public register. They're great countries to be dealing with, but then there's a lot of countries out there as well that it's very difficult. Nothing's on the public register, and it can be very difficult to obtain this information. When you're looking at places like the BVI, Panama, and places like that, it can be very difficult to actually obtain proof of who the registrable beneficial owners are. So we'll just look at a couple of examples of the process. Firstly, the Isle of Man. There's a lot of these overseas entities that are registered in the Isle of Man because it was counted as offshore, but I think some of the tax legislation has changed there. You can search a company on the public record on the Isle of Man registry, but it depends on how old that company is as to what information you can get off the public register. You can confirm that the overseas entity exists, which is important. And if it's an older company, you can confirm who the registrable beneficial owners are. If not, then you may need to request a register of members or share certificates to confirm that you've got the correct people. And then it's just a question of then confirming their identities. Now, there's various methods that we can use now to be able to do that. You could have certified copies of passports. You could do a Zoom call with the person to make sure that you can see them and confirm that that passport belongs to them. Or there's various facial recognition apps that can be used now that can confirm people's identities. It can be quite fun actually when you're conducting some of these conversations by Zoom as well, where you have people that come right up to the camera because they think that that will make them clearer, and it can be quite fun having these conversations with people when they're holding the passport up and you're going, move away. But yeah, we've had some interesting examples of that over the last couple of years. Once everything's been verified, then you can go to the registration process, which is actually quite simple. It's the verification process that causes the problems. And then once everything's been completed, the agent needs to keep a file for reference for 5 years. In case there's an inspection, you can prove how you've verified all that information. So the Isle of Man's quite a good one, not too difficult to be able to do. A lot of companies we've found have been registered in the BVI where it's a lot more difficult. We can confirm that that overseas entity exists, but then it's down to the overseas entity to provide proof of ownership, and that can be difficult to obtain. There's usually agents acting in the BVI. You've got time differences. Getting that information, they tend to work a lot slower at providing things than we do here, and sometimes it can be a bit of a rush because they need that unique identity number to be able to buy the property. So there can be some urgency there, but sometimes it can take quite a long time to get all the required information, and quite a lot of back and forth as well is involved in this process. Once you've got your proof and the nature of control as well, then you can go ahead to registration again once you've identified those people. And again, the file needs to be kept for 5 years. It can get more complicated than that as well, where trusts are involved. Again, conduct a search on the overseas entities, ascertain who the trustees are. Excuse me a moment. If the trustees are a company and they're regulated, then they can be the registrable beneficial owners, or if they're individuals, then that's fine as well. But then you need to obtain proof of the trust. You need to have proof of who the trustees are. If that's not in the original trust deed, then you'll need to obtain DORAs, which are the the declarations of the retirements and the appointments of the different trustees. Companies House also wants to know who the settlers are, who created this trust, who the beneficiaries are, and any interested parties as well. All has to be declared to Companies House. Now, that information is kept off the public record, but it does need to be declared. And HMRC have access to that information as well. Now, this is where there's lots of complications. People are very sensitive about trust deeds and providing that information, but the agent does need to verify who that information belongs to, confirm that the trust exists, and require certified copies of that information. Sometimes extracts will suffice, but it can be very complicated to obtain that information, and on the beneficiaries as well, and sometimes it will be the beneficiaries' children as well as that. So again, it can be quite a time-involved process when you're dealing with trusts. So if you do have clients in that situation, I think it's important to managing their expectations that this will take a bit of back and forth and actually take quite a bit of time to get all of that evidence together as well. So as I said, the registration process is actually quite simple. It's just a case of putting all the information onto Companies House web portal, and registration takes about 24 hours as well. The entity can actually register themselves on Companies House, and then as a second part, the agent can verify the information afterwards, but that's a bit long-winded. Our approach would be that we'd always do everything as the whole process, because the registration part is really quite simple. But that might be something that other agents decide to do and do the verification afterwards. If the entity have registered themselves, then the agent must verify the information within 14 days after that. So once registered, an annual statement is required every 12 months. Now, the filing fee for that is £234. That increased this year in May to that amount. If there have been no changes in the last 12 months, then the overseas entity can file the annual statement themselves. But if there have been changes, even if it's just a registered office address, that needs to be re-verified by an agent. It doesn't have to be the same agent, but that information needs to be verified again. And again, the agent would need to make a statement to that effect. This year as well, we've seen that an overseas entity can now be removed, and that's if they no longer hold any property or land in the UK. The one thing that I would say about this is it's really important before they apply for removal that they check that the Land Registry have updated their records. The Land Registry can take quite a while to update their records, and if they're still showing the overseas entity as the owner and they apply to be removed, and the filing fee for that is £706, then they'll reject the application because Companies House check with the Land Registry and there's no refund allowed. So it's really important that you check with the Land Registry first. As part of the removal process, if there have been any changes to the overseas entity from the original registration, they need to be verified and reported as well. And as part of the removal process, there'll be two questions asked. Firstly, has the overseas entity disposed of all relevant property or land in the UK? If they select yes, then there'll be another question. Is the overseas entity currently listed on any Land Registry records as the registered owner of property or land in the UK? You obviously have to select no at that point, otherwise you won't be able to complete the removal. And another point to make clear to your clients as well is even though you've been removed, you're only removed from the obligation to file an annual statement. The information will remain on the public record, and that's really important that clients know that. So if you need to access the Register of Overseas Entities, I've got some links on this slide. It's the normal place to go and search on Companies House. You can just type in the name or the overseas entity number, and then you can find that company, and there are documents that you can look at there as well. Or if you want to view all the overseas entities, then you can go into the advanced company search feature and select overseas entities, and then that will bring up a list of all the overseas entities on the register, and you'll see that there's over 30,000 on there now. If you want to find a UK regulated agent, there's a link on this slide for the information that can be found at Companies House. All I would say is shop around, because some of the agents charge thousands of pounds. So I think it's really good that you try 2 or 3 before you decide on one. Obviously, we provide that as well. And the Law Society and ICAEW also warn their members against becoming UK regulated agents. So that's something that you may want to think about. I believe there may have been some issues with PI insurance and things like that. So it might be something that you want to check out with your association as well. So just finally, just some transition plans from Companies House. I talked at the beginning about how there are going to be changes next year. For overseas entities in spring next year, individuals will be able to apply to have their residential addresses suppressed. I know that has been an issue with the Register of Overseas Entities. So in certain circumstances, they'll be able to apply to suppress that information. And in summer 25, there can be requests to access some trust information. Now, I don't have any more details about that at the moment, about who will be allowed to access that information. So we're going to have to wait for more news on that, and I'll let you know if I hear anything about that in the next few months. So that was a whistle-stop tour through the Register of Overseas Entities. So I'm going to stop sharing my screen now, and we'll just have a look. We've got some questions in the box. Let me just have a look at this. So first question, you mentioned that trustees that are regulated can be registered as RBOs. Following the changes made in March 2024, isn't it the case now that any trustee can be registered as an RBO, regardless of whether the trustee is regulated subject to its own disclosure requirements? Yes, I believe that's correct. Have you got anything that you want to add, Rob, on that?
No, that's correct. Yeah, the changes that came about. Now, yes, we'd have to register any trustee. Doesn't depend on any of the regulations.
Yeah. Sorry, I haven't updated my slide on that. So yes, that is correct. Sorry, I just got another question. Sorry, it's difficult to... A box has come up over the top of the question, so I can't see it. Right, what constitutes a business relationship which prohibits the verification being done? I think that's, again, one of those vague situations where the guidance states that. We had a situation, didn't we, Rob, where a company had a sister company, and within the sister company, they wanted the lawyer there to verify some of the information and certify the information, but that was a business relationship. So we refused to accept that. It needed to be somebody independent of the company. Sometimes they ask for the directors to certify some of the documents for the beneficial owners, but again, there's a business relationship there, so we would refuse that. If there are any other situations you can think of, Rob?
Yeah, I think if the relationship is, if they act as like a lawyer or an accountant, then we could accept that. But if there's an actual business relationship with them, then we'd have to end at that point, really.
Okay. Do you have to request ID docs every year you submit the return if there were no changes to the registrable beneficial owners? No, you don't have to. The overseas entity, if there's been no changes, can submit their annual return themselves, so it doesn't need to be verified. For us as a company policy, if we were submitting a return with no changes, but we hadn't done the original registration, we would go through the whole verification procedure from the beginning and request that ID as well. And that's our company policy because we were never involved in the original registration, so we have no records to show any verification took place. So that's our company policy on how we do that.
If I could add on to that as well, if there's been any changes to the beneficial owner in terms of, for example, the address, or if the individual got married and the name has changed, then we'd have to re-verify that information.
Yeah. Someone's asking if the webinar's been recorded. Yes, it has. And somebody's asking how long it takes the land registry to update their records. It's a really good question. Quite a long time, I would say. Do you know roughly?
Yeah, I think the land registry of England and Wales and Scotland, I think, is a bit quicker, but the Northern Ireland land registry does take a lot longer to feed back to Companies House. So yeah, when there's delays, that tends to be the case.
Yeah, I had somebody that contacted me last month and said they'd sold their property now and they wanted it removed. And I told him about checking the land registry, and he checked and he said, no, we're still down as a registered owner. So it can take a few weeks.
We also do checks ourselves of the land registry records. So before we'd ever do a deregistration, for example, we'd always check the data sets to make sure that the company isn't listed there.
Okay. Somebody's asked if they can have copies of slides. Yes, I'll be sharing those with everybody after. And then somebody else has just made a comment that it can take up to 2 years to register at the land registry. So that's great news, isn't it? Right, that's all the questions that we've had submitted so far. As always, my email address is on the slide if anybody wants to contact me, because often in these situations, half an hour later, you think of another question that you wanted to ask. So by all means, please don't hesitate to contact me. I hope today's session has been useful. This is our last webinar for this year. And then we'll be starting a new programme for 2025, and more information will go out about that in the new year. So just in case I don't get to speak to anybody again, have a lovely Christmas, and speak to you in the new year. Thank you very much.